right, Michelle and Steve, let's get started. Hello all, my name is Marisol Chase. I am a senior sales engineer over here at Gannett, the parent company of many familiar brands in your community, such as the Cape Cod Times, Standard Times, Providence Journal, and so much more. I am so excited for today's webinar on how the Secure Act impacts your retirement plans, and who better to educate us on this topic other than the great Michelle Beneski and Steve DeLello. To see everyone's comfortability on the Secure Act, down at the bottom, there will be a chat box. I'm going to ask a quick polling question about the Secure Act. Are you concerned about how the Secure Act is affecting your retirement, estate planning, or both? And I will also paste this in the chat so you can all respond. This webinar is supposed to be something that you can all respond to and ask as many questions as you would like. That's what we're here for. Wow, that's great to know. Seems like we're going to be able to learn from this webinar today. So Michelle is one of the managing partners over here at Surprenant and Beneski, an estate planning and elder law practice serving clients in southeastern Massachusetts, Cape Cod, and the islands. Something amazing I found out today was that Michelle has been recognized multiple times for Boston Magazine for the top women's lawyer list. Michelle and the other managing partners at the firm, Dan Surprenant, are one of two of only 25 CELA attorneys practicing in Massachusetts. This distinction makes the firm S&B uniquely qualified to handle all of your estate planning needs. When you become their client, you will have peace of mind knowing that your future, your family, and wealth are in good hands. Steve, the founder and president of Retirement Income Strategies for more than 30 years, has been helping people confidently plan and prepare their financial futures. Retirement Income Strategies takes a holistic perspective, meaning they review all of the important areas of your financial life, including investments, insurance, estate, tax, and healthcare to create an organized and coordinated plan for your retirement. Steve is also the co-author of an amazing book called Tax-Free Money for Long-Term Care and a respected member of the ED IRA Elite Advisor Program, an organization of financial professionals who are committed to the study and mastery of IRA planning. Now, these two speakers are going to be an amazing help to get us through this webinar. So without further ado, I'm going to run into a few things about what financial planning and estate planning are and why you would need both. So a holistic financial planner assesses your current financial data and helps clarify investment options. They recommend cost-effective and tax-efficient strategies to help you achieve your financial goals. They develop an overall financial plan while you're living and future legacy for your family. An estate planner, on the other hand, ensures your assets are organized and protected during your lifetime. They plan for incapacity and the what-ifs for a proper distribution upon your passing. And they provide greater assurance that all your wishes will be met and that your estate will be smoothly administered. Estate and financial planning work together. And basically this means estate attorneys and financial professionals work together to create a thorough and comprehensive plan to ensure your financial goals and estate planning wishes are completed the way you want them to be. So let's break down how they work together throughout these things. And without further ado, I will pass over the mic to Michelle to explain how her firm works and how we will have a brief understanding of the Secure Act. Michelle?
Thank you, Marisol. So thank you all for being here today. I'm Michelle Beneski. I am an elder law and estate planning attorney with the law firm of Surprenant and Beneski. We have offices in New Bedford, Easton, and Hyannis. So we cover most of the South Coast. I practice with my partner, Dan Surprenant, and we have two other attorneys that work with us, Erin Nunes and Brandon Wallaga. We all really specialize and concentrate in this area of the law. We don't do anything else. And you'll see that some of this is kind of complicated, and that's why we choose to focus in this area. As Marisol mentioned, Dan and I are two of 25 certified elder law attorneys. That's the only designation that's recognized by the American Bar Association for expertise in elder law, and we had to have a certain amount of experience and take a test for that. We've also been recognized as super lawyers, and Erin and Brandon as rising stars. We're all members of the Massachusetts chapter of the National Academy of Elder Law Attorneys. Dan is a past president, and Brandon is the current president of the Mass Forum of Estate Planning Attorneys. Dan is a member of the Special Needs Alliance. We help a lot of families with disabled people. And Dan and I are also authors of a book called Protect Your Family. So we really have a lot of experience and depth in this particular area of the law. Today, we're going to be talking about the Secure Act, and that is an acronym, because the government loves acronyms, for Setting Every Community Up for Retirement Assets. And it's a pretty big change in the retirement and the taxation of retirement benefits. It's a big change in the law that went into effect on December 20th, 2019. The government had been considering some of these changes for quite a while, but frankly, we didn't think they were getting their act together to pass it. And then in the middle of the night on December 20th, all of a sudden the bill moved, it was passed, and it went into effect on January 1st. It makes it easier for small business owners to set up retirement plans. It's supposedly less expensive for them to administer and use. It allows part-time workers to be eligible to participate in certain employer retirement plans. And that's a big change, because usually you had to work so many hours during the past year before you could qualify. One of the bigger changes is it changed the date that people need to start taking required minimum distributions out of their IRAs, their traditional IRAs, and retirement plans from age 70 and a half, you never understood the half, to age 72. So if you did not have to take required minimum distributions before January 1st, 2020, you now have until age 72 before you need to start. Another change is it allows traditional IRAs to owners to keep making contributions to those IRAs, even after age 70 and a half, which was something they couldn't do. From an estate planning point of view, the next change, it mandates that most non-spouse beneficiaries who inherit an IRA have to take all of the money out of that tax-deferred account within 10 years of the prior owner's death, before most people could stretch that benefit and take the money out a little at a time over the lifetime of the beneficiary. So that has a huge impact on estate planning. And the Secure Act also allows 401k plans to offer annuities. And that's the 50,000-foot version of what the Secure Act is. I'm really happy to be able to introduce you to Steve DeLello from Retirement Income Strategies, who is going to take us through the details from an estate planning point of view and a retirement planning point of view of the Secure Act. Steve and I work together on multiple clients, and he has a wealth of experience, and I'm proud to introduce and turn the presentation over to him. Go ahead, Steve.
Okay, thank you, Michelle. And welcome everyone here this morning to learn a little bit more about the Secure Act. So my name is Stephen DeLello. I'm president and founder of Retirement Income Strategies. I'm also a certified financial fiduciary, chartered financial consultant, and chartered underwriter. We've had our firm here in Easton for 30 years. And basically what we do is we put together customized retirement income plans for people who've worked hard for their money and want to live in a worry-free retirement. So I'm also an accountant, so I have a passion towards taxes and the development And as Maricel said earlier, I'm a co-author of the book, Tax-Free Money for Long-Term Care. So as Maricel said earlier, we're a holistic financial planning firm, and that coordinates all of the aspects of your financial world to make sure that they're optimal. Now, she gave you a little preview early on, and I just want to take a little bit of a deep dive on some of the individual pieces. So, for example, we'd want to make sure that your investments are tax efficient, that you're not being charged phantom income on and being charged taxes on income that you're not taking. Insurances, make sure you have the right insurance for the right purpose. It includes long-term care coverage, Social Security, to make sure that you're choosing the right plan at the right time, claiming strategy so that your Social Security is optimal. And then, of course, taxes. Once you retire, this is going to be the biggest expense that you're going to have. And then we coordinate all of this with your estate plan. Now, we're doing all of this under the holistic planning best interest doctrine, which comes under our fiduciary responsibility. So let's talk about what a fiduciary is. It's the highest legal duty of one party to another. And being a fiduciary requires us to be bound ethically to act in the other's best interests. So with the new fiduciary rules that went through in June, this is the umbrella we operate under. Now, let's talk about the Secure Act for a moment. The Secure Act is one of three major tax legislations that we've gone through over the last 3 years. The first one was 2017, which is the Jobs and Tax Cut Act, and that's going to sunset in about another 4 years. Then we had the Secure Act, as Maricel said, that went into effect in December. This was the largest retirement reform since 2006. And then we had the CARES Act that just went through recently. Now, let me say this. Just because Congress gives us the authority or the permission to do something that's inside these acts doesn't necessarily mean you should do them. And we're going to talk about that in just a minute. So some of these acts have got some great provisions in them, and some of them not so much. It depends on your own situation. So let's take a little bit of a deep dive into some of the provisions of the Secure Act. And we're only going to hit on a couple of the major ones. So as Michelle just mentioned, one of the things was that they eliminated, beginning in 2020, the new law eliminated a prohibition of someone who's still working and you're over 70 and a half, you can still now contribute to your IRA. You couldn't do that before. So you would have to take your required minimum distribution. Now, there's an interesting scenario we have here. So if you're over 70 and a half, you're required to take your required minimum distribution, but you also can put a tax deductible contribution into your IRA. So this is something that wasn't available, and it was something that was just off the table for people that contributed to their IRAs in the past. So why would someone want to do this? There was basically to build up money that's inside of an IRA so we can do what is called a backdoor Roth. And I'm going to get that in a second. So the other change that happened was required minimum distributions have now been raised to age 72. Now, if you were 70 and a half before December of last year, then you're going to go by the old rules and you need to take the money out of your IRA. But after December, you now have almost another 2 years before you're mandated to take money out of the IRA. Now, this could be good and it could be bad. This is one of those lemons that Congress has given us. And what do you do when you have a lemon? You make lemonade. So what we want to do here is we don't want to wait until 72 to take our RMD. And I'm going to give you 3 reasons why you do not want to wait. Number one, if you wait to 72, the factor that they use to calculate the RMD is going to cause the RMD to be larger. Reason number 2, if it's larger, chances are the taxes are going to be higher when you're 72. So we're going to be paying a bigger portion of taxes for the amount of money that you receive. And number 3, if I've let your IRA account sit for almost 2 years, we were hoping that the account would have grown. So I got a bigger amount of money, that's being affected by a larger factor that's coming out when taxes are probably going to be a little bit higher. So we have an alternative. This, we want to take advantage of what we call the sweet spot. And I think we're going to get to that. Yep. So you could delay, instead of delaying until 72, there's a sweet spot that we call a time period from age 59 and a half to 72. This is the time when you should be taking money out of your IRA and probably moving it over to a Roth IRA and take advantage of what we call a bracket pumping technique, a very strong technique. So by delaying it an extra 2 years, instead of cramming that money to come out of your IRA over a 10-year period, now I've got a 12-year period. I can take a smaller amount out and put less pressure on your tax return. So this is something we can talk about, the Roth conversion. So
Steve, these were some great insightful points, but sometimes it's a little bit confusing. Does anyone have any questions for Steve on RMD? You can write it in the chat. We'll wait a few seconds to see if anyone has any questions before we can continue on. And we will have time at the end to answer any more questions as well. Steve, it seems like everyone completely understands, so let's move on to the next point.
We're either all confused or we're totally on board. And I might want to add, if you come in for a complimentary consultation, we could talk about your particular situation individually, and we can run all the math and take care of all of that. So let's see, what else do we have on the Secure Act? We have this qualified charitable deduction. Now, remember I said there were, in the tax law, there were some good things and the things that weren't so good. This is an absolute home run. I can't think of too many places in the 75,000 pages that's in the IRS code where we're going to get this kind of an advantage. Now, let me give you a little background on what was going on here. So prior to 2017, if you made a contribution to your church or to a charitable contribution, you could take that amount of money that you gave them as a deduction on Schedule A. Well, they pretty much have eliminated Schedule A because they've raised the standard deduction. Hence, a lot of people have not given to charities as they've done in the past because they said it wasn't deductible. So charities were hurting. So Congress came out with this qualified charitable deduction. Now, it's not for everybody because you got to qualify for it. So number one, I'm going to say you would have had a charitable intent. So let's pretend that you're giving your charity, say, $1,000 every year. When you give them that $1,000, that's an after-tax piece of money that you're giving them. So you would have had to earn some money greater than that. So what this provision in the code does, it allows you to transfer money from your IRA directly to the charity. Now, here's where the benefit comes in. That $1,000 that you transferred from your IRA to the charity, you do not pay any taxes on that. You get the deduction, what we accountants call above the line. So if you're in a 22% tax bracket, that's $220 that you just saved of real money that did not have to come out of the IRA. Now here's the sweet spot. You get to deduct the $1,000 from your gross income. It's a twofer. You're going to get to save another $220 on taxes that you didn't have to pay. So they're really trying to encourage contributions to charities. Again, you got to be over 70 and a half. You probably would have had to had a charitable intent. So here's an idea. If you have to take that RMD and it's money that you don't want, you don't need, and you're paying taxes on it, why not use the RMD, that amount, and transfer it to the charity? Because you would have had to take that money out anyways. Just an idea and just a thought. What else do we have? Oh, we got the Stretch IRA, and that's gone. As Michelle had mentioned earlier, the Stretch IRA was something you could take out a minimum distribution from an inherited IRA over your lifetime. Now, inherited money, as an accountant, I'm going to tell you, is special money. You really can't do much with it. The IRA that you took that you inherited, you can't transfer the money to your spouse's IRA, can't transfer it to your IRA, and get this, you cannot put it into your Roth. The only thing you can do is take it as income. So this money has to come out of the IRA. The IRA has to be emptied on the 10th anniversary of the owner's death. Now, you might not think that's such a big deal, but if you inherited that money when you were, say, 60 or 62, what's going to happen 10 years from that time? Oh, gee, I'm going to be 72. I'm going to have to take a required minimum distribution. Plus, I probably have got already taken Social Security, and now I'm going to have this big lump of money that's going to come out of my IRA. It's going to be a disaster in your tax return. You're going to get bracket creep. My Medicare premium is going to go up. So the solution to this is we have a plan where you start taking that money out little by little over the 10-year period. Now, unfortunately, you can't stretch it beyond that, but it is what it is. But you try to avoid that tax torpedo, as we call it, in the 10th year. So Melissa, what else do we have on the Secure Act? So on the inherited beneficiaries, as I mentioned, not everybody is exposed to the 10-year rule. There is a list of 5 classes of eligible, what they call eligible designated beneficiaries that are grandfathered, and you can still use the old 10-year rule. And by the way, if someone passed last year, you're going to be grandfathered on the inherited rule. So Maricel, let's look at who those 5 classes of beneficiaries are. So they're your surviving spouse. They can stretch the IRA over their lifetime. A minor child, as long as they're minor, but does not include grandchildren. A disabled person, as long as they're disabled, chronically ill, and beneficiaries that are not more than 10 years younger than the IRA older. So the eligible designated beneficiaries can still stretch as long as they qualify. So for example, a minor child, as soon as they are not a minor anymore, they're going to be pulled into the 10-year rule. All right. So the next thing that the Secure Act did, it had a major impact on trusts. And I'm going to go over each one of these points now. So the elimination of stretch IRA for most beneficiaries has replaced the 10-year payout, has also included most trusts. What I'm telling clients now is don't trust your trust. If you had a trust put together, it's absolutely essential that you have it looked at by the people who put it together. And this is the question you want to ask. Because is my trust compliant with the Secure Act of 2019? And if you're not sure, this is something that Michelle can absolutely help you out with. So many trusts they no longer work as planned under the new rules as they were intended. By having a simple conversation with Michelle, you can avoid all kinds of havoc and problems. It's totally avoidable. Just have the thing looked at. If you've named a trust as your IRA beneficiary, which by the way is generally a good idea, your plan needs to immediately be reviewed and probably overhauled. After the Secure Act, leaving your Roth IRA to the trust instead of to the traditional IRA might be a better strategy. And boy, is that ever true. The trust gives you the ability to really control that money from the grave, and that might be a good thing for your family. So if you get anything out of this webinar, make sure you contact Michelle to have those documents looked at. Maricel, how are we doing?
Yeah, Steve, I mean, honestly, that was such insightful information, and I don't see any questions coming in, but if anyone does have any questions, feel free to go into the chat. I know this can be a little confusing, but you have 2 of the best experts on this call here for any questions, and you can also set up consultations with them to get any of your individual questions answered. But before we continue on to Michelle, let's ask a quick polling question here. So as it relates to the Secure Act, are you most concerned about your impact to your beneficiaries, managing RMDs, the impact to an established trust, or updating your estate plan? And I'm going to post those in the chat as well, so that if you can just copy and paste whatever is easy for you. And while they're answering, Michelle, I would like to pass over the mic to Michelle. Without further ado, let's go into what exactly the Secure Act is. Michelle?
Hi. Thank you. As Steve said, the Secure Act impacts your retirement benefits. A lot of my clients have left their retirement benefits to a beneficiary through a trust. And most of those trusts are what are known as conduit trusts. They say that when a payment comes out of the IRA into the trust, it must be immediately distributed to the beneficiary. And that's important, and I'll explain why in a minute. But why would they leave it through a trust? Well, one thing was they wanted to ensure the benefit of stretching out the withdrawals from the IRA over a beneficiary's lifetime. In order for that to happen, the trust had to be what we call a conduit trust, but only a little teeny amount of the amount in the IRA needed to come out in any 1 year and be distributed to the beneficiary. The trustee usually had discretion to take more out. And by doing this, a larger amount of the IRA remained invested in a tax-deferred account, and so it could continue to grow, as well as protected from creditors and things like that. That was the second reason people did this, was to leave an asset to an heir in a way that protected it from the heir's creditors, from divorce, lawsuits. Another reason was bloodline planning, to make sure that whatever they left to their heir, their child, ultimately, if that child predeceased them or their other family member predeceased them, that it stayed in their bloodline to the grandchildren, not to a new spouse or a friend. We also use trust as a beneficiary of a retirement plan when we might have a new spouse and children from a prior marriage, to be able to ensure that there was something to support the new spouse, but that maybe any balance after required minimum distributions would go to the children of the first family. And another reason, and still a reason, to leave benefits to a trust, a beneficiary through a trust, would be to leave an inheritance to a disabled person, where if they receive those benefits directly, they would lose their government needs-based benefits. And if you leave it to a special needs trust, they can receive an inheritance as well as keep those government benefits. So those are some of the reasons that people set things up this way. But now with the Secure Act, there are some potential problems in your retirement plan. So one problem is with most of these, as I said, leave the IRA benefits to a beneficiary through that conduit trust, which requires that any distributions out of the IRA into the trust be further distributed out to the beneficiary immediately. And it structures the distributions based on required minimum distributions. Well, we don't have required minimum distributions anymore for inherited IRAs. You can leave all the money in there up until year 10, and as long as you get it out at the end of year 10, you've complied with the Secure Act rules. But you need to plan for the timing of those distributions, because when it comes out, it's income taxable. And if you take, say, a $200,000 IRA out all in 1 year, something that we were using the trust to minimize those taxes, you could bump yourself up to a very high tax bracket. So you really need to work with your financial planner and your CPA to make sure that the money comes out in a tax efficient manner. Because all of the assets have to come out of the retirement plan within 10 years, and because the trust requires that once it comes out of the retirement plan, it has to be distributed to the beneficiary, any asset protection that those assets had is going to be lost in 10 years, because all of the assets will be out and be out of the trust where they're unprotected. Same thing if we did this for estate tax minimization. All of the assets have to come out. We lose the stretch on the surviving spouse, and the asset protection would be lost if the surviving spouse lived more than 10 years. And the bloodline planning would be lost after 10 years, because again, the distribution has to come out of the retirement plan, and then it has to go to the individual individually, where they are free to do whatever they like with it. So the question is, can your trust be amended to regain some of those protections and benefits that were lost? And unfortunately, the answer is yes and no. The stretch out is lost in most cases. Disabled individuals can still stretch their benefits, take benefits over their lifetime as opposed to the 10 years. But this has always been an issue with disabled individuals anyways. When you leave it to the retirement plan, in order for them to keep their benefits, it's not a conduit trust. It's what we call an accumulation trust. The retirement benefits are paid out of the plan and into the trust, and they stay there. And because of that, you get to keep your government benefits, but it's subject to tax at the trust tax rate, which is 37% on income above $12,950. And that's only the federal tax. You've got Massachusetts tax on top of it. So for purposes of bloodline planning and asset protection, we could amend your trust to change it from a conduit trust to an accumulation trust, and then the benefits of the retirement plan will have to come out of the retirement plan still within 10 years, but they don't have to be distributed to the ultimate individual beneficiary. So you keep your asset protection, you keep your, your bloodline planning. That's all great. You might be able to plan for a spouse that way. We might be able to do some estate tax administration, but you're going to subject that distribution now not to tax at that individual's rate, which most individuals are someplace between 20 and 25%, so some are even lower. And instead, are you going to be subject to the trust income tax rate? And so for the benefit of those protections, you're paying a very hefty tax cost. Sometimes those tax costs can be mitigated working with a financial planner and a financial products. Steve mentioned that sweet spot. The time if you convert your IRA, traditional IRA, into a Roth, well then if you leave a Roth IRA to an accumulation trust, we don't have that 37.5% tax because distributions from a Roth are income tax free. So there's some things that can be done together, and whether or not it's the correct thing to do for you to amend your trust, if you've left your trust to an IRA or not, is something that's going to be based on your particular family's needs. So what should you do? The first thing you need to do is figure out whether you left your retirement assets to a beneficiary through a trust. A lot of people don't. They leave things directly to the individuals. Then you don't need to worry about this. And if you did, then you want to evaluate the impact of the Secure Act on your estate plan and your beneficiaries. They have to take the money out within 10 years now, but some people have told me rather than pay the 37% tax, they're still going to leave it to a conduit trust. They're going to get 10 years of asset protection, 10 years of management of that asset for their beneficiaries. Then they won't have to pay the 37% tax. It's going to be paid to the individual, but they're accepting they're going to lose those benefits after. And others have said to me, I want to amend it. It's worth it to me in order to pay that tax to get the protections. So you need to know what benefit is right for you moving forward, and you need to understand what your plan does now and how it's impacted. So your options are do nothing. Another option might be to change your beneficiary from the trust to the individual directly, and just, they're still going to have a 10-year payout, but you don't have to worry about what your trust says. You might implement some type of financial planning. You might amend your trust, and you might do some combination of financial planning and amending your trust. You might, like I said, want to amend and convert to a Roth. So those are some things. Next steps would be to book a consultation to discuss the issues that they pertain to you in person or virtually, and what it means to your financial and estate plan. In order to do that, you have to know, and you have to bring with you so that the person counseling can know a statement for each of your current retirement plans, what kind of plan it is, a traditional plan, a Roth, a 401k, and proof of your beneficiaries for the plan. Who are you leaving it to now? As well as a blank change form would probably be helpful in case you need help changing it. And if you have a trust, a copy of your trust. In order to counsel you, we need that information. What we would do at a consultation would be to review and confirm why you chose to leave your retirement account to a trust. What was it that motivated you to do that in the first place? And then we'd help you decide what's the right next step for you, whether it's leaving things alone, amending your trust, changing your beneficiaries. And then if you need our help in doing that, we can assist you with that kind of paperwork. But if you have a retirement asset that leaves things to a trust, it's going to impact your estate plan, and you really should get that reviewed to understand how the change in law affects what you wanted to do for your family and your heirs in the future. And I'm happy to take any questions anyone has.
Wow, thank you both, Michelle and Steve. Everything we covered here was so insightful, and I'm sure you guys have questions for these amazing presenters. So we're going to open up the chat and let you ask anything you want to know about how the Secure Act impacts your retirement plan. I know I have a few, so we can start there. What is the new 10-year rule for inherited IRAs? Steve?
Yeah, for the inherited IRA still comes under the 10-year rule, and that unless you're a designated, eligible designated beneficiary, the money's all got to come out. There's only one RMD, and that's on the 10th year, the anniversary of the owner's death. And the strategy here is to pull that money out, not in the 10th year, but a little bit each year, so that you don't have the big tax torpedo at the back end.
Awesome. And I know I'm someone who loves working, and I'm sure there are plenty of other people out there. So if I'm 70 and a half and still working, can I contribute to my IRA, or do I have to still take my RMD?
Oh, that's a great question. If you're over 70 and a half and you're working, you can put $7,000 into your IRA as a tax-deductible contribution. You also are mandated to take the RMD out, but you're not mandated to put the contribution into the IRA. This is a very strange consequence of the tax law. You're putting money in, getting a deduction, and you're taking money out at the exact same time. It looks pretty weird on the tax return, but that's what we have. And it's almost like getting a discount on the money that you're taking out of the IRA. But yes, you can do both. One is mandated, one is not.
That's a really interesting concept. And I have one more. What's the time requirement for me to take action on this?
I'm sorry, say that one again.
What's the time requirement for us to take action? So let's say that we decide we want to work, we want to figure this out. What does that timeline look like?
For the RMD?
Yes.
Yeah, okay. So the official rule is you have to begin taking your RMDs by April 1st in the year after you turn, in this case, 72. That rule has unintended consequences where you, depending on the month of your birthday, you might end up taking 2 distributions in the same year. So you're going to get bracket creep inside your tax bracket. We try to avoid this whole RMD thing by starting to transfer monies during that sweet spot that I talked about. As soon as you're 59 and a half or 60, start moving monies out of that IRA. Here's a strategy. A lot of people, when they turn 66, they're at full retirement age and they think they want to take Social Security. I would suggest you think about deferring Social Security until 70 so that your Social Security benefit is 132% greater, and then create an income bridge from age 66 to 70 using the IRA money So you're going to reduce your RMD and you're going to take income out of the IRA at a discount because taxes are on sale right now. These taxes are the lowest they've ever been in history. And we know they're going to go up in another 48 months.
Thank you, Steve, for answering all those questions. And I know all of you will probably have additional questions. So if you're interested in booking a consultation with either of these amazing individuals, please feel free to indicate us in the chat. Check out their websites, message them on Facebook. We'll have their phone numbers at the end as well if you want to jot those down. And they'll be able to assist you in planning the next steps. If anyone is interested in starting a holistic financial plan or has any specific concerns about the Secure Act, please reach out to Steve's team via their website or phone for a complimentary Right Fit call and receive your bucket plan book. Steve, do you mind explaining a little bit about this book?
Yeah, this is the bucket plan book. You can see a picture of it on your screen. This was written by my good friend and colleague, Jason Smith, and it's a true story of a couple, and it chronicles the journey that they went through to put together the retirement plan, which we call the bucket plan. The bucket plan is a way to be in compliance with all these new tax rules and helps ensure that you enter into the journey of retirement in a less stressful way, and you have a worry-free retirement by the way you engineer the income that's going to be coming down. I wrote the foreword, and Jason wrote, like I said, was his client. Easy read, was a bestseller for Amazon. Come in and see us. We'll give you the book. Okay, great read.
Awesome. And if you're ready to secure your future, please contact Michelle's office for a consultation. You will certainly have peace of mind knowing that your future, your family, and your wealth are in good hands. Thank you for joining us today, and thank you so much to our presenters. I learned a lot. I'm sure everyone did. Everyone, be safe and have a great rest of your day. Thank you.